We must remind ourselves as Kenyans that while court orders have in the past sparked political motivated violence, court orders have never stopped and cannot indeed stop such violence. Only negotiated political compromise can resolve political stalemates or crises. The BBI reports and the Constitutional Amendment Bill have almost certainly been subjected to the most thorough and legally compliant public participation program of ever carried out under the Constitution of Kenya 2010. Put differently, can the judiciary, which is donated some sovereign powers by the people in Article 1(3)(c, overturn the direct sovereignty of Wanjiku, or even stop Atieno or Mueni or Mutuma from exercising this power in Article 257, Section 10 through a referendum? We, as members of the county assemblies, are very disappointed, dismayed, and dissatisfied with the recent judgment on BBI, as it sets a very treacherous and hopeless path in this country. The judgment does not acknowledge that a constitution is a living document that must be responsive to the needs and desires of a society at any given time. It presupposes that Kenyans are prisoners of the 2010 Constitution, and the 2010 Constitution was made for a tiny minority of Kenyans, and in this case the judiciary and civil society groups, not the larger majority of Kenyans. Further, this determination means Chapter 16 that touches on the amendment of the Constitution, which also can be amendment is of zero value, and in a simple language should be deleted or assumed as blank pages in the Constitution. That Kenyans demands accountability from judiciary, as it seems captured by domestic and international players who do not want a progressive society. Number 4, that judicial tyranny must stop, as such interpretation of the Constitution will easily land the country into worse post-election violence than 2007 and condemn Kenyans to eternal economic regression. In the event that the Court of Appeal or Supreme Court adopt this judgment, which we demand they don't, Kenyans will forever suffer as follows from the perspective of the devolved system of government. 1, county funds will remain at 15% of the national revenue instead of 35%. 2, 1450 wards in Kenya will never get a constitutional development fund, and governors will never develop some wards as it's the case today. Number 3, there will never be equitable distribution of county resources. Population parameter will never matter in resource sharing. So my name is Victor Karethi Mutuma. Good Lord. The statement that I've read out covers the 47 counties and is completely unprecedented at county levels and even at the national levels. So it would be improper for anybody in this Republic of Kenya. Thank you. Yes. We don't appoint the Attorney General, we don't hold brief for the Attorney General, and we can only wish him well in his discussion to the legal bodies and to the judges. Probably you may consider posting that to the team of... A public participation that is not translated to Swahili, to mother